Hi everyone, Harry here to talk about Judge Eileen Cannon's denial of Walt Nauta's motion to dismiss his indictment on a few grounds. Walt Nauta, recall, is the long-serving Trump employee and general gopher who got himself neck-deep in Trump's action of trying to shield boxes of documents from the government, who was hands-on, along with co-defendant Carlos de Oliveira, in moving boxes around and hiding them and putting them back in the warehouse, and also was very much in touch with Trump in doing so. This in the period after Trump finally receives not just a subpoena, but a search warrant, which he proceeds to bob and weave and not comply with. So Nauta was first brought up to D.C. to testify, and we haven't seen it yet, but he clearly lied about and followed the story, and they had impeaching testimony, and he was obviously in trouble. His lawyer, Stan Woodward, is someone who has represented many of the people in Trump world, and the government had him dead to rights, just for starters, for the violation of the crime of the provision against making false statements to agents. Okay, so he was indicted, and he came forward and said, dismiss it, which is a normal thing, and here's what he offered. He said, my prosecution was selective. They really zeroed in on me when they wouldn't on similarly situated other people. My prosecution was vindictive. They did it because of my assertion of Fifth Amendment rights after I had made those blunders in the grand jury. And they a special argument that they did it. They put undue pressure on my attorney to get me to cooperate. The 10-page opinion from Cannon is like straight down the middle, more so than anyone I remember. It doesn't take any swipes at the government. It doesn't indulge any outlandish theories. It just comes right out of the box with the presumption of regularity for indictments, which indeed there is, but not the kind of principle you see her emphasizing. And then she, of all things, just states the law and applies the law. So that means there is no discriminatory selection. He had to show that he was prosecuted where people similarly situated were not, which, by the way, happens all the time. That's what prosecutorial discretion sort of is. And that it was done with a discriminatory purpose. She says no evidence of that, and there is no evidence of that. Boom, boom. Vindictive prosecution, you've got to show animus, that they really wanted to have it out for you because you exercised your Fifth Amendment rights, and that's what caused the indictment. No evidence of it, end of story. And then the final little point there was, as he was coming up to testify, there was a mention made by one of the prosecutors to his lawyer about that lawyer's pending application to become a judge. And they tried to twist it in this sinister way, saying, nice little judgeship application you have, hate to see anything happen to it, as if he would need to cooperate his client in order to safeguard or maximize his chance for a judicial nomination. Totally far-fetched. I've worked in the judicial selection corridors of DOJ, and there would be no overlap, no way in which, even if the very professional prosecutor who had said that was making other than pleasantries and somehow wanted to hold it over his head, that he even could. But it's, far-fetched in the extreme in the legal community. People know who are nominees for judges, and this is chit-chat in advance of the, getting down to business on an interview. So kind of unremarkable in the denial of the motion to dismiss, but you could say slightly remarkable in its, this isn't a word, but you'll get the point, unremarkableness, because she sets it up and puts it down as a, really sort of workaday judge. No illusions on my part that this somehow marks a turn of a page for Judge Cannon. More likely, she doesn't see this as it's so important, and a clerk drafted it, and she let it just, go, and that's what accounts for its having the competence of a law school graduate, which I got to say, often Judge Cannon's own kind of homegrown crazy orders do not. Okay, so Walt Nauta sticks around, and that it would have been better for Trump if he's gone, because there's now leverage on Nauta and Carlos de Oliveira. You guys need to cooperate, and that would be against Donald Trump, or you're going to trial with the more serious charges those entail. So in that sense, that leverage remains in place for the government, and otherwise it's pretty much status quo. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.